Hey everybody, Harry here to talk about the Department of Justice's appeal for longer sentences against the most serious insurrectionists in the January 6th insurrection. Okay, so for starters, this is a pretty big deal. It's unusual for the Department of Justice to appeal a sentence, period. There's a regime in place now where the courts, it used to be, they really were pretty bound by the so-called sentencing guidelines. They could depart, but only for good reasons, etc. They no longer are, and they have more play in the joints. And typically, that means that there'll be less predictable sentences, and the Department of Justice just basically accepts that regime, especially in cases like this one where somebody has, without a doubt, gotten hit with some very hard sentences. But this really goes to show, and this is the big second point to note, the Department of Justice is all in on the seriousness of this episode and basically, is acting like, with good reason, they've decided this is one of the most grave crimes in American history, and they're going, to treat it commensurately. And then, third big point, that I think has implications for what happens to Donald Trump and Jack Smith and the January 6th set of crimes, because they are saying that these crimes undertaken by the names you've heard, Oath Keepers and Proud Boys and the like, are super serious and deserve having the book thrown at them. And if you do that and just walk away from the leaders, it would be completely inconsistent, right? So to the extent they have proof and they're developing proof that the melee itself in Congress was instigated by, or aided and abetted by, or even conspired to commit by Trump and others, it makes it seem like they're going to be going for it. Otherwise, their overall treatment is inconsistent. All right, let's talk about that in particular, though. So the number one sentence to date handed down in these cases was against Stuart Rhodes, he of the eye patch Yale Law School degree, who really kind of headed the effort. The guy got 18 years. That's a lot of time in prison. Actually, if you look at the stats for people with that kind of sentence and his age, there's a real possibility he never sees the light of day. Nevertheless, the department, when you did the guidelines, and when you talk about insurrection, there's a page in the back of the guidelines that tells you, here is criminal history on one side, and here is a robbery all the way down, etc. In what he did is top of the charts. I think it's 26 or whatever is the level. And his guidelines, even with no criminal history, worked out to 25 years. And Department of Justice has appealed to the DC Circuit and said 18 years isn't enough for a historic, dastardly criminal like him. And we want more like a guidelines sentence. And it's not just he, although he's the leader, but also 4 or 5 others who also acted with him, of Oath Keepers, including his sort of deputy from Florida, Kelly Meggs, all of them. Meggs gets a 12-year term. Guidelines was 21 years, or that's what DOJ sought. And then lesser people got like 4 or 5 years, but their guideline sentences were in the teens. So the DOJ is looking for all of these, and also a few others. These are the 2 Oath Keepers who were acquitted of seditious conspiracy, but convicted of conspiring to obstruct Congress. Jessica Watkins, Kenneth Harrelson, they wanted 15 years, not 4. And Watkins, they wanted 18 years. She got 8.5. And now you can think about this also sort of globally. Like, you have literally 1,000 people who've been charged so far, and both the department and the courts just wanted basically to get rid of the first layer of people who more or less wandered in to the proceedings, or did trespass or did something bad, but there are just so many of them. Basically, they got pretty easy sentences. It was just a matter almost administratively of giving them something and getting them out. And so there the courts and the DOJ were kind of a like mind. But as it gets higher and higher up, you get to points where really you have to think about it in individual sentences. And courts are looking at the lower sentences of the lower people, and just in general, not used to seditious conspiracy. It's not surprising. In fact, at the time when Rhodes got 18 years, that's a pretty strong sentence. And his sentencing judge, who is an Obama appointee, gave him a stern lecture and said, "You're no patriot," that kind of thing. So in some sense, the courts were serious, but DOJ, looking at it globally, says not serious enough. Now, we don't have memos of law or anything like that so far. What's happened in the cases is each of the defendants, and this is just a matter of course, has appealed the conviction as well as the sentence, and DOJ had until yesterday to just file a piece of paper, and the piece of paper just said, "We appeal the sentence." So it's a two sentence thing. You don't know what the argument is, and you don't know what underlay it, but you can be sure the Solicitor General herself had to approve these appeals, as is always the case. She knows that you don't do this willy-nilly for sentences for the overall credibility of the United States. There must have been everybody in the room who had any impact at all, and the people who, from the prosecutors who brought the case said, "Look, this is if we're not going for guideline sentences here, where would we go for them?" And perhaps whether or not Jack Smith's folks were in there or not, the SG would keep in mind, we may down the line be looking to throw the book at the actual conspirators who spearheaded it all from the Oval Office, not to exclude possibly the former president of the United States. And the United States needs to take a consistent position that this is way, way, way serious, and that the courts need to treat it that way. Now, generally, courts are not so, but they want the courts of appeals, for the district courts, to have a lot of discretion. They're not in the business of changing sentences from 10 to 14 years or the like. So in a normal case, you might think that this wouldn't succeed, this appeal. It's technically a cross appeal, the lawyers call it, because the defendants are also appealing. You wouldn't think it would, but then in a normal case, the United States might not challenge it. This is not a normal case, to say the least. It is all wrapped together, probably the biggest case in the history of the Department of Justice, and they are putting down a marker saying, for all the serious actors on the ground, and you can bet any other serious actors they identify who the people on the ground were doing the bidding of, also have to be treated with the utmost seriousness. So we'll see whether the Court of Appeals takes that view also and feels that it's sort of worth its time to do a rare kind of knuckle rapping of the district court and say, nope, you really needed to not do this, what was technically downward departure from the guidelines. You didn't explain it well enough or whatever, and you need to increase the sentences. So we'll see. That'll play out. Not quickly, because there'll be briefing and argument and the like. So that will play out. It's another reminder that this whole big sprawling case, it's not just Trump. It's not just next November. It's going to be going on for a while. But it'll be important to see what the Court of Appeals does with the United States urging to really give the leaders on the ground of the insurrection at least the sentence provided by the guidelines. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.